Welcome to the channel, ladies and gentlemen. This is a story that comes out of Mesa, Arizona and features Richard Weed, otherwise known as Arizona Unfiltered, on YouTube. Now, you've probably seen this video around, but that's not what you're going to get. Today, I'm just going to do a read-through of the events and give you a play-by-play with some snippets of the body cam footage that goes along with all of this. This is probably one of the most disturbing cases of overreach and corruption that I've seen in a long time.
I just wish you knew.
On December 12th, 2024, in Mesa, Arizona, Richard Weed, known as Arizona Unfiltered on YouTube, was subject to a traffic stop, supposedly for unusual noises from his truck.
Hi, Officer at Mesa Police Department. Any weapons in the vehicle?
I don't answer questions.
You don't answer questions. Okay,
No.
driver's license, insurance, registration.
Sure. What'd you pull me over for? 'Cause I wasn't speeding.
Unusual noise from the exhaust.
The officer inquired, "Are there any weapons in the vehicle?" To which Richard responded, "I don't answer questions," asserting his right to remain silent and not answer the question. After pulling Richard out of the vehicle to conduct a conversation with him at the rear of his vehicle, an officer watching the passenger that they didn't pull out of the vehicle observed an axe in plain view in a gun rack in the back window of Richard's truck.
No, you remove the person. You don't go through the fucking vehicle, you idiot.
Is that a gun?
Yeah.
And a gun?
Yeah.
Where was the gun?
Driver door.
All right.
He then entered the vehicle without any consent or probable cause and discovered a handgun in the driver's door pocket after he took the axe out of the window, which both were in plain view. The firearm was not concealed as defined by ARS 133102, which excludes visible firearms from the statute's scope completely. Richard was immediately arrested and charged with misconduct involving weapons under Arizona Revised Statute 133102, which requires an accurate answer when an officer asks whether a person is carrying a concealed deadly weapon. The prosecution on this case, led by Assistant City Prosecutor Austin Brooks, contends that Richard's refusal to respond violated this statute. However, the evidence demonstrates the firearm was not concealed at all, as defined by ARS 133102, which excludes visible firearms from the state's scope, a fact the prosecution itself concedes in its very own filings, noting the gun was in plain view when the officers seized it. Further examination reveals additional defects in the state's case. The officer's question, "Are there any weapons in the vehicle?" does not align with the statutory requirements inquiring specifically about concealed deadly weapons. ARS 133102 imposes a duty to accurately answer, only when that precise question is posed, as evidenced by body camera and dash camera footage.
Any weapons in the vehicle?
I don't answer questions.
It wasn't. Richard's response, invoking silence or simply refusing to answer the question, does not constitute a failure to accurately answer, as the statute does not mandate speech, and the Fifth Amendment protects against compelled self-incrimination. Moreover, the search of the vehicle violated the Fourth Amendment under Terry v. Ohio and Michigan v. Long. A protective search requires specific, articulable facts indicating immediate danger, facts completely and utterly absent here. Given the axe's passive presence and the availability of less intrusive means, such as ordering the passenger to exit the vehicle per Maryland v. Wilson. The prosecution's reliance on the plain view doctrine completely fails, as the initial entry lacked any legal or lawful justification, rendering the subsequent seizure of the axe and then the handgun inadmissible. The integrity of the traffic stop itself is in question. No objective evidence, such as a decibel meter, supports the noise violation that was the whole point of the traffic stop to begin with. An audio from Richard's dash cam suggests the stop was motivated by a vehicle sticker, not an exhaust, a discrepancy undermining the officer's probable cause. This renders the stop completely unlawful, tainting all evidence as fruit of the poison tree. In court on February 19, 2025, prosecutor Austin Brooks acknowledged the case's weakness, reducing the plea offer from an initial $1,000 and a surrendering of his firearm to just $300, and that's it. Yet here he persists in prosecution, possibly under the direction of some Mesa leadership. Who knows? Richard has filed several motions to dismiss, citing the firearms visibility, the improper question, and the unconstitutional search, his protected silence, and additional motions to suppress evidence and compel discovery, including officer communications, are warranted, I do believe. The prosecution's position is legally untenable, and this case exemplifies a misuse of judicial resources, malicious prosecution, and overall governmental misconduct.